Thank you, my Lords. Perhaps I could begin by trying to deal with a loose end from yesterday, which relates to the question of solvency and what issues and evidence were before the Grand Court. We've produced and agreed between the parties overnight a note which summarises the position and hopefully will be helpful. Just to take you through that very quickly.
Or should we just read it to ourselves first?
Yes, of course, yes.
Yes, what do we get from that?
So I think firstly, clearly the issue of solvency was alive on the pleading and plainly was one of the issues before the Grand Court, as I said yesterday.
Right.
So far as the evidence is concerned, there wasn't agreement as to the existence of the non-redemption liabilities. Right. That was a non-agreed fact. But there was material put before the Grand Court annexed to the statement of non-agreed facts to support the proposition that those liabilities existed.
There's a curious concept of a non-agreed fact standing as uncontroverted evidence of the trial, which is a new one on me.
With that, I mean, that struck me as well when I read the consent order. It does seem as a contradiction in terms, but it may not matter for our purposes.
What is the material which exhibited? Is it just the trial balances prepared by the administrators?
Exactly. So these are the balances that are prepared essentially on a monthly basis by the administrators, primarily used for the purposes of calculating the fund's net asset value to do the redemptions and the subscriptions.
But I mean, by definition, that was simply a statement effectively by your clients.
Well, not by my clients, by the former administrators of the fund, which is now BNY Mellon, who are the... When I say administrators, yes, I mean the pre-insolvency administrator of the fund, which was the service provider, yes, which during the lifetime of the fund kept the yes, fund's books and records and produced them now. Yes.
Who are they, pre-insolvency?
It's now an entity, it's now part of BNY Mellon, yes, the well-known bank. I think at the relevant time, it was in a previous incarnation. I think
don't worry about it anyway. All right. Well, we'll hear what Mr. Chivers says about that.
And certainly, I mean,
you say that was sufficient to require the judge to make some finding.
Sufficient to enable him to have made a finding as to solvency on the basis of...
I mean, if that was all he had, why does it need to go back to the judge? I mean, if it's just one document.
Well, it is. I mean, I think the slight difficulty I have in making that submission to your lordships is that the trial balance itself has not been included in the record for this appeal. Yeah. It obviously was part of the material before the Grand Court, but just looking at the position before the Chief Justice, the evidence he had was the trial balance produced by the pre-insolvency administrator. It's a reasonable inference that the administrator had some ground for including the liability within the trial balance, and there was no evidence put forward the other way at all. No disclosure was sought from the other side going to this issue. So it would have been a relatively straightforward submission to make to the judge.
I mean, is it evidence if someone just prepares accounts? I don't know what basis the documents were, the relevant documents pertaining to each disputed fact.
It seems to have been assumed that there would not be oral evidence.
Yes, that's right.
So maybe this is an agreement to have the trial on documents. And
in any event, the liquidator is an officer of the court and would normally report the financial state of the company in a fairly informal way.
This is not the liquidator. This is the pre-insolvency administrator of the fund, the person who's just the manager, effectively.
Well, it is, but I mean, of course, he's charged with keeping the books and records of the fund and critically producing the NAV calculation.
Yes.
Which is
All right. Well, we'll hear what Mr. Chivers. You say that's good enough.
we do. And I mean, you've obviously got my submissions on why this doesn't matter anyway, because our primary position is you take redemption debts into account for these purposes in any event. So, my lords, having dealt with that, I pick up where we left off yesterday afternoon, which is the question of the right of restitution, which in our submission is ultimately a question of law, whether there is a right of restitution exercisable by a company in liquidation for recovery of a redemption payment made in breach of the statutory requirements. And we say, obviously, that there is. In the present case, if the redemption payment was not permitted under Section 37(3), then it was unlawful, either contrary to Section 34(2) or Section 37(6). Now, except there is no express right conferred by the company's law to recover a payment made in breach of those sections, but they do render the payments unlawful.
But your submission is that if a payment is unlawful, it automatically follows without more that it is repayable with or without notice at the relevant time.
Yes, subject.
But on what do you base that proposition?
Well, subject to two qualifications to that. Firstly, obviously there would be a change of position defence in principle. And the second qualification, which is the key one, is whether the plaintiff's right of recovery is barred because he was a party to the illegality, commonly described under the rubric of whether he was in pari delicto or not.
Yes, but I mean but there's a more fundamental question. That your starting point is that subject to a number of special defences, and you've outlined what they may be, there is a right to restitution simply by virtue of the illegality of the payment. Now, on what do you base that proposition?
Well, in my submission, as I'll show you in a moment, I mean, that is the premise on which Smith and Bromley proceeded. I suggest that ultimately, at the heart of the matter, there was an action for money hadn't received to recover an illegal payment. And the question was simply whether the plaintiff was...
Are you going to take us to that?
I am, yes. But, my lord, the other way I would put it is to say that even if there isn't a general right to recover illegal payments in the way you've described, where the purpose of the statute is to protect a particular class, there will be such a right of recovery. And I will show you in a moment the treatment in Goff and Jones, and then one goes to cases like Carreri Cotton and analyses what is the basis for the right of recovery in those cases.
So there's a right to recover the 23 million, but also, I think you accept this, a right on the part of the redeeming shareholder to claim it.
In the liquidation?
Yes, in the liquidation. And that in practice, he'd have to claim it in the liquidation, but he could, let us suppose that the company at some subsequent stage, not relevant for the purposes of Section 37, but at some subsequent stage, became solvent again. Now, he could presume there would then be no liquidation, but presumably the redeeming shareholder could claim in that situation.
If the company is restored to a state of solvency, so it's then,
Yes.
it then comes out of
But too late for the purposes of Section 37, which requires that there must be a solvency at the time.
Well, in my submission, yes, because in those circumstances, the purpose underlying the prohibition has entirely fallen away. I mean, the purpose of the prohibition in 37(6) and 34(2) is to protect the general body of creditors, where by definition there is a shortfall.
But I mean, if the company's in liquidation and it suddenly becomes owns a gold mine, it can pay 100% in the liquidation, so it doesn't matter.
Exactly. I mean,
Comes out.
I mean, my point, I think, is in no circumstances the whole purpose of 34.2 and 37.6 would fall away. And
it's a slightly odd situation.
Everyone is paid in full in those circumstances.
It's a very odd situation, which I suspect is not paralleled in any of the reported cases, though I could be wrong about that, that a sum of money is owed as a valid debt. It's nevertheless repayable by way of restitution, but notwithstanding that, you are entitled to prove for it in full and recover for it to the extent of the assets. I mean, this is a combination of contradictory propositions that seems slightly odd to me.
Well, I mean, we obviously take issue with that, and I think the purpose, one goes back to the purpose of the prohibition, and the purpose of the prohibition is not to invalidate the debt as such, is to invalidate the distribution made to the shareholder or former shareholder. That's what the purpose of the rule is concerned with.
The whole point of your case is to ensure actual pari passu distribution, and no doubt if it had been determined what share a particular recipient actually was owed in the liquidation pari passu, then you might get arguments, well, why should they have to pay back the whole thing in order to recover that share? That you might even have a set-off. I don't suppose you could technically, but
in practical terms, you might.
In practical terms. I wanted to ask a slightly different question, namely, bearing in mind that we're told that in fact the payments out, I don't know whether by coincidence or more, roughly correspond with the pari passu shares that would be payable in liquidation. Why are you bringing this litigation at all?
Well, I mean, that part of the respondent's case is wrong. I mean, that's paragraph 100.
It's wrong, I see. So they don't correspond roughly.
Well, it's paragraph 108 of their case. I mean, they make that point there. I think they make it in some slightly earlier paragraphs.
It's mathematically inaccurate.
Well, it's inaccurate because they ignore the prior ranking unsecured creditors who have not been satisfied, on which, on our case, there's 12 million.
Oh, I see.
And they fall to be paid in priority to redemption creditors under Section 49G. And they also ignore the liquidation expenses. I mean, the liquidation expenses...
I'm sure they're large.
Well, they cover matters as mundane as the petitioner's costs. And, you know, obviously all the incidental matters that are recoverable as well. So it's not... That proposition is not right on the facts. And the purpose of the action is to bring in that money, so it's then distributed in accordance with the statutory scheme, and that would mean paying ordinary unsecureds first.
Yes, I mean, the pari passu distribution principle is obviously, it's a statutory principle, and it's the basis on which, with or without notice, there are a number of statutory provisions which entitle the liquidator to claw back, e.g. preferences, notice or no notice. But the basis of that is that the statutory right clearly operates irrespective of notice. What we're concerned with here is a common law or equitable right of recovery, not founded on statute at all. Now, I mean, I understand that you say that there is a statutory protection for creditors, but what we are concerned with is the extent of that protection. And it doesn't seem to me at the moment that the protection extends to displacing the ordinary rule of the common law of restitution, that a payment made in discharge, or in this case partial discharge, of a valid debt is not recoverable because it's not unjust. The unusual feature of the problem that we have is that you have got a valid debt which is nonetheless illegal for the company, and it's the company's conduct which is illegal, no one else's. The company is not allowed to pay a valid debt.
Yes.
And there is no statutory clawback provision, as there is, for example, where there's a preference.
Well, there isn't, but what there is the statute renders the payment unlawful, and the question is, well, what is the consequence of that? And in our submission, where one has got a statutory prohibition, which one can say is imposed for the benefit and protection of a particular class, then that...
Actually imposed for the benefit of the company and the class of beneficiaries who gain, I mean, the creditors gain by the protection of the company's assets.
Well, I mean, we would say in substance it's imposed for the benefit of the creditors.
Because the test is whether the company can pay its creditors in the ordinary course.
Yes.
Don't you think you ought to show us some authority?
Yes, I mean,
I think
absolutely.
you've got the statement of principle
Yes.
that you're arguing for, and my lord.
Yes, absolutely. I mean, I was going to start, I think, if I may, just by showing you the relevant passages of Goff and Jones, because they provide a survey and summary of the cases in this area generally,
Good, yes.
which we're relying on. That's in Authorities Bundle 3. And if we can just pick it up, Divider 67. Chapter 25, where the book deals with illegality. And they make the point in the first paragraph that illegality may be relevant as a defence to a claim.
Sorry, where are we?
As page 1805, so paragraph 25-01. Just at the introduction to chapter 25, the first paragraph, they make the point that illegality may be relevant as a defence to a claim, which is broadly the issue the Supreme Court was concerned with in the Patel case. But, as they say in the second paragraph, illegality may also be relevant in two other ways. And the first of those is where protection of persons in the claimant's position is the very reason why the agreement.
But it's talking about agreement here in both these paragraphs, and we're not talking about an illegal agreement here.
Well, we'll come to that in a moment, but certainly one of the submissions I'm going to make to your Lordship is, whilst an agreement can be per se lawful, it's certainly possible to perform it in an unlawful manner and thereby, in effect, make the agreement unlawful. I mean, there's a case of Mr. Justice Devlin that makes that point, which I'm going to come to. I mean, one may have an agreement which is perfectly fine on the face of it, but it's the manner of performance which renders the...
We were talking about people who carry goods in overloaded vehicles or
yes,
ships.
That was the Charter Party case.
Yes. Well, it's St. John's Shipping.
Yes.
But
I mean, we'll come to it.
that's a claim by the ship to recover freight, wasn't it?
It is, yes.
And well, it's rather different from it's the other way around here, isn't it?
Well, I mean, I accept that. I mean, obviously the facts of all of these cases are rather disparate, but the point in St. John's Shipping was that the Charter Party itself was perfectly legal. It was the way that it had been performed that made it illegal. But anyway, I mean, one sees at 2502, illegality will be relevant where protection of persons in the claimant's position is the very reason why the agreement is illegal. And then that is developed really in 2507, Smith and Bromley, which I'm going to come to in a moment, over the page, Carreri Cotton, which I will also take your Lordships to. There's two possible limits to the right of recovery. They identify in 2509, firstly, which is a point which arose in a case called Lodge. I don't think that's relevant for our purposes. It deals with the question of the terms on which the court can grant relief in a case where the party is seeking the return of security or similar. And then the second principle, the second limit to the right of recovery, 25-12, relates to a case called Green against Portsmouth Stadium, which my learned friend relies on. And that was basically a case where the right to recovery was denied because the statute itself didn't confer a right to bring the recovery. But as they say in 25.14, that presumption is displaced where the statutory provision is enacted specifically for the protection of persons in the claimant's position. Refer again to Carreri.
Yes, but these are all cases. You haven't shown us a single case in these passages which, where the both parties were not party in one way or another to the illegality.
To the illegal facts.
That's right. So,
I mean,
that's
if
right.
you take the cases about restitution of money paid by local authorities under swap agreements held to be ultra vires, no doubt neither party appreciated the legal limits of the power of the local authority, but the critical factor which justified a restitutionary claim was that they were both involved in the facts,
yes.
knowingly involved in the facts which gave rise to the illegality.
Yes. Well, I mean, if one takes the situation in Kariri Cotton, which is perhaps the most straightforward, except one's got a very straightforward situation there, in that it involves two persons, the tenant and the landlord.
Yes, we agreed to pay a premium, and
yes.
premiums being
and the tenant's claiming recovery of the payment from the landlord, and under the relevant legislation, the duty is placed very clearly on the shoulders of the landlord. So one's got a purely bilateral situation, a transaction taking place between two parties. It's very straightforward. Now, the present case does undoubtedly have another dimension, because there are essentially three bodies involved. You've got, firstly, the company and the directors as they stand prior to the company going into liquidation. You've got, secondly, RMF as the particular redemption creditor who receives the payment. And thirdly, one's got DD Grove's general body of creditors. And in effect, one has three bodies at issue in this case. Now, the transaction, the prohibition in our submission is imposed for the benefit of the third of those bodies, the protection of the general body of creditors. I mean, that's quite clearly the purpose of
as Matt points out, the prohibition is itself a protection. You seek to suggest that the protection goes so far as to justify recovery from innocent recipients of the money, and that's the key question we need some authority on.
But
I don't know of a parallel case.
Yes, but what we rely on is the proposition that where one has a prohibition in a statute which renders a contract or a transaction unlawful, and that is imposed for the benefit of a particular class, then that class will have a right of recovery. Now, the question which arises is whether that right of recovery is barred because the class is a party to the illegality in some way, and that's the way it's been.
But that's starting at the first floor. The question surely is not whether the right of recovery is barred, but whether the right of recovery ever exists. The first stage of any restitutionary claim is to demonstrate that the enrichment of the, in this case, the redeeming shareholder, was unjust.
Yes, and we rely on the illegality, the unlawful nature.
They weren't in any way. The recipient hasn't a clue where this payment is coming from. If it was integral to the payment out that it came out of capital, or if the recipient was told, look, we're just going to use this piece of capital, that might be slightly different, but they might then be party. But the feature of this case is that all the recipient does is receive money. And there's no, it's not party in any way to the fact that the money may come from capital.
For which it's given good consideration in the form of a discharge of a valid liability.
Yes, I mean, let me take you to Smith and Bromley, because, I mean, in our submission, the way this works is that money hadn't received for an illegal payment, and the question is whether it's barred by illegality. Now, Smith and Bromley is behind Divider 21.
You'll facts are summarised in the passage that you asked us to open up in Goff and Jones.
That's right, yes. And the report itself, it features as having been read out in the course of judgment in another case called Jones and Barclay. The facts are straightforward. The claimant's brother was subject to a commission of bankruptcy. His main creditor refused to sign his certificate of discharge unless he was paid £40. That was paid by the claimant to the creditor, who then sued for its recovery. Held that the payment was illegal and that the claimant had a right of recovery from the defendant. And if you go to page 443, one sees...
443 of the English reports.
It is, yes, my lord, yes. Page 818 of the bundle. What Lord Mansfield said... if the act is in itself immoral or a violation of general laws of public policy, there the party paying shall not have his action. For where both parties are equally criminal against such general laws, the rule
Sorry,
is,
where are you reading from?
I'm reading from...
About 5 lines, 6
Yes,
lines
about
down.
5 lines in on page 443. He said, if the act is in itself immoral or a violation of the general laws of public policy, there the party paying shall not have his action. For
Sorry, I'm still not with
I'm
you.
sorry, I do apologise.
Page 443
of the English reports, page 818 of the
I see,
bundle.
right.
It's about 6 lines down.
No, I'm there now.
Thank
Forgive
you.
me.
If the act is in itself immoral or a violation of the general laws of public policy, there the party paying shall not have his action, for where both parties are equally criminal against such general laws, the rule is potio conditio defendis. But there are other laws which are calculated for the protection of the subject against oppression, extortion, deceit, etc. If such laws are violated and the defendant takes advantage of the plaintiff's condition or situation, there the plaintiff shall recover. And it's astonishing that the reports do not distinguish between the violation of one sort and the other. Now, in our submission, how this analysis proceeds is on the basis that illegal consideration will be recoverable by way of a common law action for money hadn't received, even absent any statutory remedy. And the question is whether the statute is for the protection of a class of whom the claimant is a member.
It was illegal because, I mean, I'm not sure I understand 18th century bankruptcy law sufficiently, but having committed an act of bankruptcy and having no assets, he was apparently entitled,
Yes.
So to speak, free of charge to a certificate of discharge.
Effectively.
But basically, the objection was to the creditor gaining more than he was entitled to under the rules of distribution
Yes.
by refusing to sign a certificate which was otherwise a proper certificate.
Yes, and using that as withholding his signature as effectively as
So the
leverage.
money was recoverable from a person who had committed an illegal act.
But in terms of the analysis, I mean, how this proceeds in our
And the poor chap who'd been effectively forced to pay out, the defendant or those who had paid on his behalf, were held to be the people who were intended to be protected by the
Yes.
discharge and entitled to the discharge. So they were not, although they were parties to the illegality, they were not in pari delicto.
Well, that's right, but the important point in our submission is how the analysis works, which is one starts from the proposition that the consideration passed under the illegal transaction will be recoverable. The question is whether the plaintiff's right to recover is barred because he is in pari delicto. And
Well, if you jump, I mean,
the third item of
if you jump over the first stage, of course you get to that question. But the real question we're worried about is whether you can categorise the present transaction as one which was illegal, and illegal if it's relevant to the extent that the recipient of the monies could be said to have been party to it.
Yes, but in my submission, how this analysis proceeds is on the premise that the illegal consideration is recoverable.
You keep on asserting that,
Yes.
but I don't sort of see it. And,
Are you submitting that effectively what Lord Mansfield is saying in this passage is you can recover it, one, if the parties are in pari delicto, and two, if the relevant rule is designed for the protection of a class of persons who will benefit by the restitution, whether in pari delicto or not? I think that is what you're saying.
Yes, I mean,
I
that's
think what you're saying, this is a two-part test that Lord Mansfield is putting forward, and involvement in the illegal act is only relevant for the first half. Is that the submission that you're making?
Yes, I think that's right. I'm not entirely sure I caught all of what your lordship's saying, but what we're saying is that where where the plaintiff is part of a protective class, he will have a right to recover an illegal payment, and that right will not be barred by treating the plaintiff as being in pari delicto with the defendant.
Mm-hmm.
So the protected class principle can operate at, I suppose, two levels. One says, well, if he's a member of a protected class, he has the right. But also, and this seemed to be the point Lord Mansfield was focusing on, is he won't be regarded as being in pari delicto with the defendant so as to bar that right. So,
Well, I wonder if you can read that. I mean, the second sentence says other laws for the protection of the subject against oppression, etc. If such laws are violated and the defendant takes advantage of the plaintiff's condition and or situation, I mean, it is the defendant's act in breach of the law to protect a subject that gives rise to the unjustness of his retention of the sum. It seems, using a civilian approach, the question is his retention of the sum unjustified? Now, if the defendant is the innocent party to the transaction, having no knowledge of the illegality, why is it unjust that he retains sums paid in discharge of a valid debt?
well, because one is in a situation here where in substance there's two innocent parties, the general body of creditors and the creditor who received the payment, and the statute says the payment was unlawful, and that prohibition is imposed for the benefit of the general body of creditors.
I mean, this is actually the classic area of operation of the law of constructive trusts, and in particular knowing receipt, isn't it? That is the principle of law applicable, which entitles a company to recover its misapplied assets, even from a party who received those misapplied assets in discharge of a valid debt. But it's absolutely critical that equity will only allow that if the condition of notice is satisfied.
Yes.
Now, you are essentially invoking what you say as an absolute common law principle in an area where it simply doesn't seem to apply. I mean, there are established equitable principles for dealing with the situation in which we find ourselves.
Well, I mean, that's right, in the sense that those flow from a different basis. One's looking at ultimately the director's breach of duty and applying the first limb of Barnes and Addy, and that's subject to all the requirements your lordship says. But aside from that, what's important here in our submission is one starts from the proposition that the statute renders this payment, if we're right, unlawful. Now, that's not something which would be a necessary ingredient, actually, of a Barnes and Addy claim. One could found the Barnes and Addy claim simply on the basis of the director's breach of duty. The statute specifically says that the payment is unlawful, and the question is, well, what is the consequence of that, if any? And in our submission, where the purpose of the prohibition is to protect a class, that class is entitled to bring an action in restitution to recover the payment. And that's basically simply applying the principle set out in Goff and Jones. It's essentially...
Can we get some help from analogies in any other area? I mean, look at fraudulent preference. Is that something that can happen unilaterally as far as the company is concerned? In other words, the recipient of the money may not be involved, may not know that they're being preferred. And in that situation, what's the basis? Is it an express statutory basis, the recovery from the recipient there? Well, it may well be.
Yes, I mean, the fraudulent preference laws still apply in Cayman are based on an actual intent to prefer. And
exactly.
It's
so
the
subjective intent of the...
It's the company's intent.
Of the company.
Yes.
But the right of recovery is expressly conferred there
by statute.
by statute,
yes.
Irrespective of notice.
Yes.
But
So, well, you've got to find
this is a
something.
common law stroke equity right of recovery,
Yes.
not
but
a statutory claim.
Right, but I think one,
It succeeded on the preference claim, it would have been different.
yes. The preference is clearly rather different. I mean, as you say, it's subject to an express right of recovery. I mean, so far as this point is concerned, we obviously found ourselves on the statutory prohibition.
Yes.
And we say, well, because there is a statutory prohibition, because that is imposed for the benefit of a particular class, then we're in essentially the same position as the tenant in Careery Cotton. We're entitled to recover. And we're not precluded from recovering by being regarded as being in pari delicto or party to the illegality in any way. Now,
Do you have any case law where there's an illegality by a breach of a legal provision which is designed to protect a class, where the recovery is allowed in unjust enrichment against an innocent recipient? Because that seems to me to be the question.
I think the example we have of that is, I think...
Because Smith and Bromley certainly isn't such a case.
No, it's not. I agree. I mean, Smith...
Murray
is
is
a
your
case
nearest
called-
example, isn't it?
Sorry?
Murray is your nearest
Yes,
example.
exactly.
Murray, which
Judge
What we've got
Hodges.
is a decision called Murray Vernon Holdings.
well, where's Murray then?
If your Lordship just bears with me, if your Lordship the reference
In
to that, it's
Gotham
tab
Road.
45 in volume 2. This was a case concerning unlawful financial assistance. Where there is various allegations made, but the key point was that under, I think, section 151 of the 1985 Companies Act, financial assistance is rendered unlawful.
What, for the purchase of the company's shares?
Yes.
Yeah, okay.
And the judge in that context dealt with the question of whether there would be a restitution claim against the recipient, effectively, of the financial assistance.
But the recipient,
That is
was
a-
the recipient the person who had purchased the shares?
Yes, so the money was paid out
Or who
to
had
someone
acquired
in order to assist with the purchase of shares in the company.
The recipient must therefore have been privy to the facts which rendered it illegal.
Well, I'm not sure because, if one looks at the way the judge deals with it at paragraph 66, page 1218. He deals with this point over on page 1219.
It arose
The
in
way-
a rather tangential way, didn't it? It was his
Well, it
analysis
did.
of whether the company suffered any loss.
Yes, it didn't arise as...
But this wasn't actually a claim, as I understand.
no, it didn't
for that
arise at the
recovery.
heart of his decision because...
This is over to unreasoned and wrong.
Who says this? Who is responsible for this observation?
Mr. Chivers.
I see.
you see...
The Goff and Jones don't seem to mind it.
Goff and Jones cite it at length, but...
But
your
is it-
Lord's right. If you go to paragraph 65, the opening sentence, he's dealing with the question of loss at this stage.
But is it clear that the recipient was innocent here? Your summary of the facts don't suggest that he was.
Well, I'm not sure. I don't think I can submit that to your Lordship because, it was within a group of companies.
Yeah, it was a transfer from holdings to a group company to enable Mr. Caulfield and Mr. Hassel to be paid for their shares that very day.
Yes.
It does look as if they might have been involved a bit.
Yes. I think what I can say is if you go to paragraph 66 on page 1219, the way that the judge analyses the rule on the basis of Goff and Jones is exactly the way we would analyse it, which is it depends on the transaction being rendered illegal, and then whether the purpose of the rule rendering the transaction illegal was for the protection of the party seeking to effect recovery. I mean, that's the way he analysed it, which much in my submission is the way it's put in Goff and Jones, and is not based on the wrongdoing of the recipient. It's more looking at, A, is it illegal, and B, if it is illegal, what was the purpose of rendering it illegal and for whose benefit?
But if you get into the question of in pari delicto at all, I can see that it might be said that the company was, that what was being argued here was that the company was more to blame because it was upon the company that the relevant legal obligation that was broken rested. But all of that proceeds on the basis that both parties are involved and that one of them is saying, nevertheless, you aren't entitled to get the money back because it was your illegality more than it was mine. Now, that's a completely different issue to the one which arises here. We're not concerned with in pari delicto because one of them was just not involved in the relevant illegality at all.
Yes. I mean, yes. I mean, I think the question of in pari delicto is not apt in the present case. But in our submission, you go back to the point that one's got a prohibition expressly rendering this unlawful. It is for the benefit of creditors, and therefore creditors should have a right of recovery. And it's not barred by treating the creditors as being party to the company's illegality. And I mean, the other key proposition on which we'd found ourselves is the way Lord Mansfield put it, not in Smith and Bromley, but in the other case, Browning and Morris, which we can perhaps pick up from the speeches in Patel, in Divider 49 of Volume 2, behind page 1360. And this was actually in the speech of Lord Sumption, but you'll see how the point was put by Lord Mansfield in Browning and Morris. Where contracts or transactions are prohibited by positive statutes for the sake of protecting one set of men from another set of men, the one from their situation and condition being liable to be oppressed or opposed upon the other, there the parties are not in pari delicto, and in furtherance of those statutes, the person injured after the transaction is finished and completed may bring his action and defeat the contract. Now, within that, there are 2 points, I'd suggest, when one unpacks it. One is the ability to bring the action to defeat the contract. So he clearly regards it as being the case that in this position, there is an ability to bring an action and defeat the contract, in his words. And the second point, if one unpacks it, is that is not prohibited by regarding the plaintiff as being in pari delicto with the defendant. So those are the 2 aspects. We obviously say, well, those apply equally in the present case. We are exactly in the situation where the statutory prohibition is imposed for the purpose of protecting one set of men from another. In other words, the general body of creditors from particular creditors who receive payment when the company's insolvent.
Against whom are the general body of creditors protected?
Against any individual creditor who receives payment when the company is insolvent.
Albeit that creditor is in no way party to an act of exploitation.
They're being protected, surely.
Is it really
against the
protection?
misbehaviour of the directors in authorising something in breach of an obligation that was directed at them.
Yes.
Is it really a protection against people, or rather protection against the inappropriate reduction of the company's capital, which is there for their protection.
Well, those are suggest two sides of the same coin, in the sense that the reduction of capital, obviously will involve an outflow to a particular creditor.
Yeah.
But ultimately, what this is concerned with, we suggest, is protecting the general body of creditors against individual creditors being paid redemption payments in full when the company is insolvent. That's what this is concerned with, if we're right on construction. It's about saying, well, you've got to preserve this capital. You don't send it out of the door to redeem one creditor in full in circumstances where the company hasn't got enough resources remaining to meet all its creditors in full. So in that way, it is designed to protect the general body from individual redemption creditors being paid in full. So in our submission, we are within the way Lord Mansfield puts it, in Browning and Morris. It is a case where the prohibition's imposed to protect one set of men from another. And in our case, we submit you can't regard the general body of creditors as being party by the pre-insolvency illegality of the directors, in essence. Now, I was going to show your Lordship's career cotton, the facts of which I accept at the outset are somewhat different, but it is important to see what was said there. That's in Authorities Bundle 3, Divider 56. And the facts, I suspect, are very familiar to your Lordship. It was a case where a tenant of premises had paid the landlord a premium on a lease. The payment of the premium was contrary to the Ugandan rate restriction ordinance. And you see the relevant provisions of that at page 194 of the report, 1524 of the bundle. It was section 3.2 of the 1949 rent restriction ordinance. And basically that prohibited the receipt of any money other than rent in consideration for the letting or subletting of a dwelling house. Now, what's important to note is the statute didn't confer any civil right of recovery, but it did impose a criminal offence. Now, just tracking it through, one sees firstly at page 195 the argument that was put to the landlord, basically in support of the proposition that there was no right to recover. One sees that about 7 lines in on page 195. This case can safely be considered in light of the English common law. The first submission is that the Uganda ordinance does not give a right of recovery to a person who pays a premium. A non-proper construction of the ordinance, the penalty for asking or receiving an illegal premium, which is provided by that subsection, is the sole remedy, and no civil action can be founded thereon. And then secondly, the respondent was barred by proof of illegality from suing to recover the money. So 2 points were basically put: one, no civil right of action, and second, the tenant was barred by his own participation in the illegal conduct. Page 198, you see Mr. Scarman's argument, which he put for the tenant, towards the top of that page. There are 2 sound ways recognised by the common law in this class of case in which that task of construction can be approached. On either of them, the respondent is entitled to succeed. The first, the common law gives a cause of action for the recovery of money paid under a legal contract when the plaintiff is not in pari delicto with the defendant. Illustrations of that can be found where one is faced with the oppressed and the oppressor, with a class protected by statute. Whatever the position be with regard to oppressor and oppressed, on the facts here, this case certainly comes within the second illustration, a statute passed to protect a class, and the plaintiff being a member of that class. And then, you'll see at the bottom of the page, he cited in support of those propositions Browning and Morris, Smith and Bromley, both of which we've looked at. And in our submission, basically the argument that was being put on behalf of the tenant was the argument that was accepted as being correct by the Privy Council. And if you go to page 1532, towards the bottom of the page, Lord Denning refers to Hastelow and Jackson. Two parties enter into an illegal contract and money is paid upon it by one to the other. That may be recovered back before the execution of the contract, but not afterwards. In accordance with this principle, so long as the illegal transaction has not been fully executed and carried out, the courts have in many cases shown themselves ready to entertain a suit for recovery. So that's dealing, if you like, with the locus penitentiae line of cases. But then he goes on about 9 lines down. But so soon as the illegal transaction has been fully executed and carried out, the courts will not entertain a suit for recovery unless it appears that the parties were not in pari delicto. It is clear that in the present case, the illegal transaction was fully executed and carried out, and the money was paid, the lease was granted. It was and still is vested in the plaintiff. In order to recover the premium, therefore, the plaintiff must show he was not in pari delicto with the defendant. I'm sorry, my lord, I was...
No, don't worry.
1533, page 203.
Yes. First of all, don't worry about me.
Well,
then-
do we get a huge amount of assistance out of this case? Because we understand the way the principles of in pari delicto work, and they postulate that both parties are party in a real sense to something which is an illegal transaction.
But the way it was put, both in argument and the way he analyses it, is consistent, we say, with the way Lord Mansfield approached it, which is that where there is an illegal contract, there is a right of recovery unless the parties were in pari delicto, because he identifies the critical question.
Not if it's fully executed, which here it is.
No, that's... I mean, that's not what he's saying with respect, because what he says...
Not where there is an illegal contract, it's where both parties have been engaged in an illegal transaction.
Well,
That is the premise on which Lord Mansfield was considering this.
That's, in my submission, not how Lord Denning puts it in this case.
Where doesn't he put it? Where does he put it differently?
Well, it's the critical bit in 203, about 9 lines down. But so soon as the illegal transaction has been fully executed, so he's now moved on to...
Unless it appears the parties were not in pari
Exactly.
delicto. So the postulate is that they were in delicto, and both of them. The question is whether they were in pari delicto. So the whole postulate is that you've got a bipartite illegality.
Well, in my submission, the postulate here is that one has an illegal contract.
Well, it isn't an illegal contract, it's a payment.
An illegal payment, which one party, and he's postulating it on the basis that there will be a right of recovery unless the parties are in pari delicto.
Well,
I mean, that's...
I think we're going round in circles. I mean, it's not very helpful to take a case which is clearly dealing with a different situation and to argue that just because a payment is a transaction, therefore all payments fall within this principle.
Well, it's...
Transaction here was one where both parties were party to the illegality, and what we're lacking is some helpful case which deals with the present problem.
Yes, I mean,
So,
I don't want to repeat myself, but I mean...
No, I think we got your basic point. How much further do we go on restitution? Is there any other basis of restitution apart from the one you've been emphasising?
I don't think so, no. I mean, I think I've I mean, I think I've made the point.
Yes. Well, you'll have a chance to reply.
No, I mean, my lord, those are my submissions.
Mr. Al-Atta, is there anything you want to add on this point? No, thank you. Mr. Chivers.
Thank you, my lord. The first thing to point out is that my learned friend's proposition applies not just to Cayman and to this statute, but would apply generally. He's making a general proposition as to rights of recovery, which don't simply affect companies in liquidation. There's no element of the liquidation that he has relied on in respect of his claim. And therefore, it would apply to any payment by anyone where that payment is not lawful, the recipient is innocent and unaware of the unlawfulness, and the only gloss that my learned friend puts on it, which he says gives the right to recover, is that the illegality is there for the protection of the claimant or someone who has an interest in the claimant and who would be benefited apparently by this. The second thing, of course, is that although this is unlawful, it's no different from any other unlawful distribution. The statute does create a criminal offence, but that criminality certainly hasn't been established here. It's where the directors of the company knowingly and willfully commit the offence, make the return of capital. The matter is unlawful. So I don't think
it's only, as I understand it, the company or its directors.
Company or its directors.
Who would commit the offence.
That's right.
No doubt there would be this common law offence of aiding and abetting, but apart from that, there's no illegality on the part of the recipient.
That's right, and the common law offence of aiding and abetting could only apply if they had knowledge. So we're back to knowledge. Now, my learned friend in the appellant's case says at 495, paragraph 912, that the shareholder in this case is in no different position to a shareholder who receives an unlawful dividend. Now, subject to questions which may arise over consideration on an unlawful dividend, of course, this is a case where consideration clearly has been given. An unlawful dividend can be recovered from a shareholder on ordinary and clear principles. And precision dippings is such a case. And in precision dippings,
should we look at it?
Which we can look at. It's supplemental bundle. Tab 2 of the supplemental bundle. This was a case brought by the plaintiff company. It was a wholly owned subsidiary of the first defendant company, and the second and third defendants were the sole directors of both companies. So it was an action against the company that had received the dividend and against the directors who were responsible for the payment of that dividend. And this was to do with the 1980 Companies Act. We'd looked at the 81 Act, but before that, the common law rules as to distributions in the United Kingdom were put on a statutory basis and subject to particular conditions. And you'll see from the head note, cash dividend of £60,000 was paid. The relevant accounts by reference to which it failed to be determined without contravening Section 39 of the Companies Act were for the purpose of Section 43(1) of the Act, the plaintiff's last annual accounts. The auditor's report in respect to those accounts was not unqualified, but at the time the dividend was paid, no statement as to the materiality of the qualification had been made by the auditors as required by Section 43(3)(c). Now, without going to those sections, you can see immediately this was a particularly technical issue. There was an unqualified auditor's report. The auditors had not made a statement as to the immateriality of that qualification as regards the distribution, and therefore the distribution was unlawful in accordance with the statute. Now, the Lord Justice Dillon dealt with the case in this way. One can pick it up at 1854 D. The payment of the dividend of £60,000 was therefore an ultra vires act by the company, just as if it had been paid out of capital or in any other circumstances in which, under any of the other provisions of Section 39 and the following sections, there were not profits available for dividends. So you can see we're in just the same territory as we are here.
So you accept the analogy, yeah, right.
Yes. In those circumstances, can marketing have any defence to the company's claim for repayment of the £60,000 with interest? In this connection, Section 44(1) provides, where a distribution is made by a company to one of its members in contravention of the foregoing provisions, and at the time of the distribution he knows, that's the member, knows or has reasonable grounds for believing that it is so made, he shall be liable to repay it, or that part, as the case may be, to the company, or in the case of a distribution made otherwise than in cash, to pay the company a sum equal to the value of the distribution. There can be no doubt that because Mr. Wynne Jones and Mr. King were the only shareholders in and directors of marketing, that's the holding company, and were also the only directors of the company, marketing must be taken to have known all the facts. But it did not in fact know the terms of Section 39 and 43. I do not find it necessary to examine the wording of Section 44(1), since by subsection 2 the provisions of Section 44 are declared to be without prejudice to any other obligation imposed on a member to repay a distribution unlawfully made to him. I put the position quite shortly. The payment of £60,000 to marketing was an ultra vires act on the part of the company. Marketing, when it received the money, had notice of the facts and was a volunteer in the sense that it did not give valuable consideration for the money. That, of course, is where we differ from this case, as my Lord will appreciate. But for the purpose of the recovery action...
You say that accepting something in discharge of a debt is giving valuable consideration.
There is debate on that question, and some of it is, I think, going to the Court of Appeal in the BTI and Susquehanna case.
Well, isn't it essential that that be the case for your purposes here?
Well, for the purpose here, we say that we have a lawful debt arising out of a lawful transaction. We gave consideration for that debt, and the discharge of that debt will be in consideration of the underlying obligation.
Yes, sorry, but I thought you said that that was a controversial proposition.
No, the controversial proposition is that where you have a dividend, the question is that a transaction where the shareholder has given consideration?
The only relevant transaction there is the payment of the dividend.
Yes.
And the shareholder has given no consideration specifically related to the receipt of the dividend.
That's the argument.
All that's happened is that he owns some shares.
Yes.
Quite.
And the argument in the Susquehanna case is whether a dividend is a transaction at an undervalue within the insolvency legislation.
Well, that gives rise to clawback provisions, which, so far as they apply at all, apply by statute.
That's right. That's right. But that question, the consideration question, doesn't concern us here.
You say you had a lawful debt due for payment.
That's right.
The provision...
Using a civilian, again, by analogy, obviously, this is English law, using a civilian analogy of unjustified enrichment, you would say you have a justification for retention.
That's right.
The lawfulness of the debt.
That's right. But just to see how it's dealt with on an unlawful
Can I, before we leave this particular point, ask you, Section 44(1), which is quoted in Lord Justice Dillon's judgment.
Yes.
Has there always been express provisions for repayment on condition of unlawfully paid dividends, or was there a stage at which it was governed by the common law? And if the latter...
Yes, before 1980 it was governed entirely by the common law.
And was there a...
Because the statute itself didn't provide for the payment of dividends.
So what was the common law position on repayment of unlawfully declared dividends?
The common law position was exactly the same.
I.e. notice required.
We've got Flitcroft's case in the authorities where the directors were responsible for the payment of an unlawful dividend.
And was that... and was recovery there dependent on notice in the same way as under the statute?
Recovery was against the directors. What one finds in the authorities is that the recovery is against the directors who are responsible for the unlawful dividend. Now, the issue was discussed in Queen's Moat House, which we can go to in the authorities. And
Yes, where is that?
But why, you couldn't recover against the recipients of the dividend at common law, why not?
well, because the basis of the claim was that the payment of a dividend out of capital was ultra vires the company.
Yeah.
It was therefore in breach of trust of the directors, who were trustees of that money. They paid it outside the terms of their trust.
No,
and if you...
why couldn't you claim against the... Why wasn't it possible to claim against the recipients of the dividends?
Because they didn't have notice.
Yes, but if,
It's a question of notice.
if they did have notice, then
Yes.
then the law English law of constructive trust.
Then there's a...
They didn't have notice, but
Which is
shouldn't
precision
that have been held to be irrelevant for the same reasons as given in precision engineering or precision case, namely that they didn't give valuable consideration?
Yes, that would be another ground.
Well,
They put both grounds in precision.
Yes,
Yeah, well, they
Precision
double
dipping,
whammy in precision dippings. They had notice and they didn't give consideration.
yes, right.
that's right.
But
So there was the constructive trust.
What we're searching for is, I suppose, whether the present issue is being explored pre-1980, and I get the impression it hadn't been. Flitcroft's case is a different defendant and different...
No, there was a discussion of it in Queen's Moat House
Well,
as
let's look at that.
dividends are concerned. And
Where is that?
thank you, tab 44. Issues had arisen in the case as to whether directors might seek contribution from shareholders who had no...
Yes, not on the ground that they had a parallel liability.
There's a there's a discussion there. So Queen's Moat House is at tab 44. And the precision dippings was discussed. The unlawful dividend section starts at 1178 at paragraph 29. Findings in respect of unlawful dividends. There is a reference to the provisions of the insufficiency of distributable profits. We're now in 263 of the 1985 Act, and we're looking at the descendant sections of the 1981 Act, which had come in respect of the European Directive. There's some discussion of that, but you'll see at 1179 the reference to
Market precision, yes.
quotation there, statutory code designed to avoid that difficulty, making it entirely clear on the face of the accounts whether or not a payment of a dividend is properly made. Code is designed to be a major protection for creditors and members. And then it's just worth pointing out at this stage, Queen's Moat House was a solvent company. This is a case of the recovery of unlawful dividends under the statutory provisions, but the company was solvent and continuing, and that's what gave rise to some of the interesting questions. 33, judge's reference to precision dippings. Lord Justice Dillon then discussed that. He said that compliance wasn't a procedural matter, could be waived. Mandatory nature. And then he goes to Flitcroft's case. I took you very briefly to Flitcroft's case, just to one of the statements about reduction of capital. But you can see there's a summary of that at 38, and it might just be worth reading about Flitcroft's case just from the report.
Well, Lord Justice Robert Walker at paragraph 47 is interesting, isn't he?
Absolutely, that's what I wanted to bring you to after Flitcroft's case. But before that, at 44, you'll notice at the bottom of 1181, there's a reference to the fact that it makes no difference that the company is solvent, it can still bring a claim in respect of the unlawful dividends. In other words, we're not just looking at the position of an insolvent company. If this rule applies in respect of an unlawful payment, it applies whether the company is solvent or not. And the discussion then went on to the question of whether the directors would receive an unmerited windfall, shareholders would, on the basis that you get the unlawful dividend and then you recover it from the directors. The company recovers it from the directors, and then the company distributes the proceeds again to the shareholder.
Well, what is interesting about Lord Justice Walker's analysis is that he clearly regarded the equitable principles as relevant to govern the liability of the shareholders, and those, of course, as he points out, are principles that depend on notice.
Yes, that's right. And at 40...
But interestingly, he then goes on to say, well, of course, now they do have notice, but he then says, well, they may have changed their position. And you would say, well, or they may have given good consideration
exactly,
for this charge.
They may have given good consideration.
Yes.
So
it's all the same familiar principles.
Familiar principles. But you'll see at 46 that that discussion arose in the context of the last sentence of 46. Any unfairness would arise from long-term investors not being required to account for the unlawful dividends which they received in the past. And then that's the context in which that discussion arises. But certainly this provides no authority for the suggestion that there is some other basis, money hadn't received basis, which simply by virtue of the unlawful nature of the payment, the monies could be recovered from the shareholders. It's on the line which had been taken throughout that this is an equitable remedy and therefore it turns on notice. Now, interestingly,
Well, I mean, you accept that the remedy potentially exists, but you say it's subject to qualifications. If the money has been, if there's been a change of position, or if the money has been received for consideration, then it doesn't exist.
Well, the remedy is a remedy based on the breach of duty by the directors and the question of notice. It's a constructive trust remedy.
Yes.
So that's the remedy. It's not that there isn't some separate common law rule which applies here because of the unlawful nature of the payment, some prima facie rule that you can recover an unlawful payment just by virtue of the fact you say, well, I paid this to you, I'm very sorry, I wasn't allowed to. Interestingly, that windfall argument, you can pick up a whiff of that in the Murray-Vernon case that my learned friend took you to. And
A case like Bairstow and Queen's Moat not discussed in Goff and Jones and other textbooks? It's a separate head from the
it's a separate head, I think.
restitution from the illegality, a party to illegality head.
Yes, because they
must be discussed.
Bairstow, yes,
Yes.
I think they must be. I mean,
Yes.
Bairstow is again in our
Yes.
supplemental authorities bundle.
Right. I'm sure they're
Sorry, not
extensive.
Belmont. I'm sorry, I was going to take you to Belmont.
Yeah.
The supplemental authorities. But first of all, just to deal with the decision of His Honour Judge Hodge, just keeping in mind the windfall nature of what was going on, this was actually a circular action between people who had a company that had given unlawful financial assistance in respect of the acquisition of shares, and the controllers of that company who had benefited from that, then seeking through the corporate structure to get that money back. And it was in that context that this that the comment was made at paragraph 66 by His Honour Judge Hodge in respect of the restitutionary claim. Now, when he said Holdings had a restitutionary claim to recover the unlawful financial assistance it had provided, if by that he means a claim based in constructive trust, of course that was absolutely right. That is a straightforward application of the doctrine that we have been discussing, that it's unlawful to give financial assistance. Therefore, if you receive a payment that amounts to financial assistance, you know, and you know of the illegality, you know that that payment has been made to you in breach of trust by the directors because they had no power to do it. It's an ultra-virus payment. And you're held to be a constructive trustee because you receive it with notice. The only thing here that was being discussed, so if one says restitutionary claim, of course, in broad terms, that can include a claim by way of constructive trust. And then His Honour went on to reject the submission that the company which has provided unlawful financial assistance is precluded from bringing a claim in restitution by the rule that money paid under an illegal contract is irrecoverable. So what His Honour was dealing with there was the defence of illegality that might...
It's a Kiriri Cotton case, isn't it?
Kiriri Cotton case.
I mean, he's already found that Mr. Hassel was party to the breach of fiduciary duty involved in the unlawful assistance.
Well, more than that, as you'll see from the postscript to paragraph 72, this claim falls to be dismissed. I'm entirely satisfied it's Paul and JJ who have initiated and pursued this litigation. They've done so out of ill will towards Mr. Hassel, with a view to their own ultimate benefit and gain. They've sought to hide behind the separate corporate existences of Holdings and the Group, hoping to recover the price paid for the minority shareholdings by Holdings, while at the same time retaining the benefit of those shareholdings for Group. So it's the windfall. They were trying to use the unlawfulness to recover a windfall. Now, there, notice wasn't an issue. these individuals, just as in precision dippings, were involved in both companies, and so notice went all the way through. So His Honour Judge Hodge was quite right to say there was a restitutionary claim. But if my learned friend says, well, he was basing that purely on the fact of the receipt of an illegal payment, he was wrong. And this case certainly goes nowhere near that, establishing that. The other case in the supplemental bundles that we put in light of the approach my learned friend was taking, was Belmont Finance, number 2. And Belmont Finance number 2, it was a financial assistance claim, and one can simply pick it up at the judgment of Lord Justice Buckley at page 405, 1828 in the supplemental bundle. There was a conspiracy claim which was dealt with earlier, but we needn't be concerned with that. But it may just be worth looking back at 1827, between C and D. The unlawful purpose in this case was the provision of financial assistance in contravention of Section 54 of the 80 Act. The purpose of the sale was to enable Mr. Groscurth to pay £489,000 to City for the share capital of Belmont was known to all concerned. So we have the unlawfulness, we have the knowledge. So he then comes to the constructive trust point, and between B and C, there's Barnes and Addy, limited company not a trustee of its own funds, fiduciary character of their duties as directors of a limited company are treated as if they were trustees of those funds of the company which are in their hands or under their control. They misapply them, they commit a breach of trust. They misapply, they come into the hands of a stranger, etc., etc. It becomes constructive trustee. Clearly by Masterfield's Jesselyn, Russell and Wakefield Waterworks. In this court, the money of the company is a trust fund, and so forth. Present case, the payment of the $500,000 by Belmont to Groscurth, being an unlawful contravention, was a misapplication of Belmont's money. It was in breach of the duties of the directors of Belmont. Found their way into the hands of City, with City's knowledge of the whole circumstances. Must follow, City is accountable to Belmont as a constructive trustee. First of the heads. There's then an issue about dishonesty, which one doesn't need to go into.
As a matter of fact, do you have to receive the monies with notice, or is it, if you receive the monies innocently and later acquire notice, is that, are you not potentially liable subject to change of position defences?
Well, subject to consideration issues as well.
And consideration issues, yes.
Subject to consideration issues.
If you receive the money for no consideration, notice would no longer be relevant.
Well,
But if you received it for good consideration,
Yes, I see.
then the discharge occurs at that point, and subsequently acquiring notice would not unscramble it.
Yes, that's the position.
I don't think there's any difficulty with those principles. The position, therefore, is that there is, and there have been recognised for many years, a route by which companies recover unlawful dividends, unlawful distributions of capital. And it is based upon the constructive trust arising out of receipt of money with knowledge of the director's breach of duty. The remedy that my learned friend seeks to establish, as my lords have seen from the cases and commented, simply doesn't arise on their face. I'd like to take you to Smith and Bromley again, just to a couple of passages that weren't, I think, looked at by my lords in discussion with my learned friend, but which are telling. It's at tab 21 of Bundle 1. first is 817 at 442 of the report. At the first full paragraph, halfway down, Lord Mansfield was of a different opinion. He said it was iniquitous and illegal in the defendant to take, and therefore it was so to detain this £40. Now, here, Lord Mansfield is dealing with the claim, the cause of action that arises. If a man makes use of what is in his own power to extort money from one in distress, it is certainly illegal and oppressive. And whether it was the bankrupt or his sister that paid the money, it's the same thing. Taking money for signing certificates is either an oppression on the bankrupt or his family, or a fraud on his other creditors. It was a thing wrong in itself, before any provision was made against it by statute. For if the bankrupt has conformed to all the law requires of him, and has fairly given up his all, the creditor ought in justice to sign his certificate. On the other hand, if the bankrupt has been guilty of any fraud or concealment, the creditor ought not to sign for any consideration whatsoever. If any near relation is induced to pay the money for the bankrupt, it is taking an unfair advantage and torturing the compassion of his family. So there he's dealing with the illegality in the defendant taking the money. It's wrong for the defendant to take. And it uses that word take. Then, at 443, third line down, it is argued that as the plaintiff founds her claim on an illegal act, she shall not have relief in a court of justice. So then he goes on to the paradelictu defence and the laws of public policy. And these are laws he's talking about, other laws calculated for the protection of the subject against oppression, extortion, deceit, etc., if such laws are violated, and the defendant takes advantage of the plaintiff's condition or situation. There the plaintiff shall recover. So it's very clear that the illegality here was on the taking. And the concluding words of the report of that case at 819, at the end of the first incomplete paragraph on the page, upon the whole, I'm persuaded it's necessary for the better support and maintenance of the law to allow this action, for no man will venture to take if he knows he is liable to refund. There's a nice instance of knowledge. Not simply knowledge, but venturing to take if he knows he's liable to refund. It couldn't be a more different case. There's nothing one can get by way of principle from that case which supports the idea that a person who themselves committing an unlawful act makes a payment to an innocent person has any entitlement to recover from that innocent person that payment.
For good consideration.
For good consideration. Well, or it may be at all, my lord. It may be at all. I mean, we're not... Most of these cases, well, many of these cases, of course, one is looking to see what is the basis of the right of recovery. Sometimes it's said, well, once you unwrap the contract, there was no lawful consideration, and there's simply a claim for money hadn't received. Well, that's quite right in that respect, yes. The Kariri Cotton, that my lords have already seen. And as far as that case goes, again, it's a case where very clearly the illegality was on the recipient of the money, who took the money with notice, and public policy did not prevent the claimant from getting that back. But that was an unlawful transaction case. A very different case from this one.
Well, it was an unlawful transaction in which both parties were involved in the facts that made it unlawful.
They were both involved in those facts.
Are you, you do accept in the present case that the question whether your clients had notice is one which has to go back, if you're right on the principles, but has to go back for trial?
That's agreed.
That's agreed.
That's agreed between the
So
parties.
if we're deciding anything, it's simply the theory or the principles.
Well, the theory or the
text,
principles, well, I'm not quite sure that's right. The way that my learned friends had put it in their case was that there was before you a claim in restitution which this panel could determine.
Yes, quite right. On his case, he says he can go through without obstacle.
Yes.
But on your case, you say that the test is different and depends on notice and...
Well, I think we're both agreed that there may be a claim in constructive trust which has to be examined.
Go back. Yes.
This panel isn't concerned with the principles upon which that constructive trust claim will be determined. This
We
panel
are
hasn't been
concerned
asked.
with the question whether, if there is a right of recovery, it's going to depend on the law of constructive trust or not.
Yes.
And it's uncontroversial, I think, that if it depends on the law of constructive trust, then it depends on notice.
Yes.
Yes. So, I mean, if it weren't otherwise, we might not have cause for sending it back. It might be nothing to argue.
That's right.
We do have to decide something on that point.
Yes. The issue that my learned friend is trying to do, he's trying to shortcut that and say, well, you don't need to send it back.
Quite
Illegal payment. And it's that principle that,
Which we should
that this court has to decide.
You submit. Yes.
I don't think this court has to make any determination on the constructive trust question at all, because both parties have agreed that that would have to be remitted.
Yes. I mean, it's not quite as simple as that, because one is looking at the general architecture of the law in this area. At any rate, it seems to me that a requirement of notice, which would be imported by the law of constructive trust, responds to the general equities of the situation as they've always been recognised.
Yes.
And one can't disregard that in deciding what, if any, remedies exist.
My Lord, I accept that. And of course, we have pointed out that those remedies are there as a matter of principle. In other words, there isn't a gap in the law that needs to be filled. But I did want to say something about the question of whether that gap ought to be filled, because my learned friend hasn't pointed to any authority which gives him such a claim. In other words, he's asking this panel to create such a claim. Now, firstly, as we've discussed, there is a route by which, in an appropriate case, recovery can be made of an unlawful dividend. So there isn't that gap. The legislature has not thought it necessary to fill that gap, which is a long-standing, knowledge has been a long-standing requirement of a claim for recovery against a shareholder. And one's seen even where the English legislature, the UK legislature has taken steps to put a statutory remedy in place, even that required notice.
Is there any parallel in the Cayman?
No, because
legislation?
Cayman is still on the common law as regards distributions.
Right.
There is no, you don't make distributions by reference to certain accounts or something like that. It's left entirely to the pre-1980 common law. So there's no reference to it at all.
But you're now dealing with something of a chimera, aren't you? I mean, Mr. Smith hasn't asked us to invent some new head of restitution. He says it's covered by existing authority, and you're
Well, he
You're
says
saying that there
but
is
sorry, my lord.
well-established principles of constructive trust, and there are well-established principles dealing with illegal transactions to which both parties are involved, and there's no cause to start inventing new law outside those categories.
That's right. I think my learned friend accepted that none of the cases were on point. And if
Well,
none of the cases are on point,
I
this
think
would be
he
the first.
submitted that they were in point.
Well,
Well, you said there was an underlying principle
yes.
illustrated by the cases.
He accepted that
Wasn't
none of the cases
Directly.
were on point on their facts, but he said that some of the statements of principle nevertheless covered wider facts than
Well, there
those.
we are. But I would just like to point out there is good reason why the English legislature, sorry, the UK legislature, limited the statutory right of recovery to knowledge-based recovery. Firstly,
When you say the English legislature,
sorry, the UK legislature.
UK.
In 1980, when it put it on a statutory base, albeit without prejudice to any common law rights, it would be odd if putting a statutory notice-based provision, why one would do that if there was some other remedy which was not based on notice. But there we are.
It depends on what knowledge of the common law you attribute to
that may do. But the particular issue is that a shareholder who receives a distribution in good faith shouldn't have to treat that as a provisional payment. Shares are, by their nature, capable of being traded, being transferred. There is a market in them. And those markets are of great importance to the jurisdictions in which companies trade. In Cayman, the market in respect of these companies and these funds is hugely important to the jurisdiction. But this isn't simply a Cayman-based thing. If one thinks about this jurisdiction and the trading of shares on the stock exchange and the importance that plays, it's a matter of great significance. Now, the lawfulness of dividends can be extremely technical. We've seen from precision dippings. It could be an entirely internal matter as to whether or not the dividend is lawful. For example, public limited companies commonly fail, as they're required to do, to make a dividend lawful. They fail to file with the registrar of companies interim accounts when they pay a dividend by reference to those interim accounts. So the last annual accounts don't show enough profit. They make a profit in the interim. They're allowed by the statute to draw up interim accounts, and they pay the dividend by reference to those interim accounts. But further formalities have to be complied with. Those accounts have to be filed. Now, frequently that doesn't happen. Companies make mistakes, and they don't file those accounts. This panel may or may not be surprised to know that there are frequent occasions on which major public companies trip up in that respect. And in respect of that, the dividends that they pay to thousands, if not hundreds of thousands of shareholders are unlawful. There's no doubt about that. Some of those are picked up and attempts are made to remedy it. Some of those are not picked up. But the idea that the market, when you buy and sell your shares, if you sell your shares come dividend or ex-dividend, as will happen when a dividend is declared, and then prior to the record date, you sell your shares, or you sell your shares after the record date, but before the dividend is received. The idea that the value that is shifting between the buyer and the seller should somehow turn on the internal workings of the company's accounting process as to whether the buyer or the seller may be liable to repay that distribution would be extraordinary. So there are very good policy reasons for maintaining the position as it is on a notice-based way of dealing with lawfulness. If you have a basis that is not based on notice, then trading in shares, receiving dividends, dealing with those dividends, funds that receive those dividends and then pass them on and so forth, that would be in difficulty. And it's no answer to say, ah, well, there may be a change of position defence. There may or may not be. But one doesn't create a cause of action based on the possibility that there might be some equitable defence to it. Markets require certainty, and a rule which required shareholders, put them under strict liability to return distributions made unlawfully, would make markets highly uncertain. And my lords will bear in mind, this isn't a question of insolvency. This is a question of companies that are solvent and trading perfectly properly, and may not become insolvent at all, as in Queen's Moathouse. Or it may be a case where, to go back to our examples of yesterday, a redeeming shareholder in a Cayman fund puts in a redemption notice. The company pays them 90% within time, but is unable to pay the remaining 10% until the day after the due date. Now, on my learned friend's case, that 90% was paid unlawfully. The company is still solvent, it's carrying on. 2 years later, it goes into liquidation, and the liquidator apparently has a no knowledge-based claim against that shareholder for the recovery of the 90% that was paid unlawfully, because the company was unable to pay by the due date a small amount afterwards. Now, those sort of considerations simply should not apply to shares, to trading in shares. There's no policy reason for it to do so. The Act has created a specific regime, in this case in Cayman, in making, firstly, the payment unlawful, and secondly, where there is knowledge on the part of the directors, criminal liability on the part of the directors and the company. But they're the gatekeepers. And if they let the money out of the gate, it's gone, unless there is notice on the part of the recipient.
There's no other remedy if the directors aren't willfully party, though, is there? It's slightly curious to have a prohibition without any remedy except if the directors have a certain status.
Oh, no, my lord. Section 6A makes the payment unlawful. 6B creates...
Yes, I know, it makes it unlawful, but that's not a remedy for making the unlawful payment. It's a prohibition on making it.
No, well, my lord, it's a remedy in the sense that it's a breach of duty on the directors to make the payment, and therefore there's a constructive trust
It would be liable.
that the recipient would notice.
The director.
They would be liable in any
Directors
event.
are liable.
Strict liability as far as they're
So
concerned.
they're liable because it's a breach of trust, unless they can get relief, unless the court relieves them from liability under the statutory power to do so.
Right, under the, yes.
Then they're liable. My lord raised with my learned friend the question of whether there is any other example of such liability, and one got into the question of preference. And I just thought I ought to say something about that, because I think the discussion proceeded on the basis that there was an express statutory remedy to recover the payment. It's not the case in Cayman, actually. Oh. It's the case in this jurisdiction.
It is in England, isn't it?
It is in England. In Cayman, there is a remedy, but the remedy simply says that the payment is void. So there is a statutory remedy in that sense. It says the payment's void. It doesn't actually say, and the recipient shall repay the payment.
Right. Is the voidness of the payment, does it mean any more than that the payment is illegal? If the payment's actually been made...
My lord, I raise it because, again, this is a matter that this panel is going to consider in another context. And I thought I should raise it with you now.
We should keep off preferences.
Keep off, please, preference, because you will have to consider that in another context. But I didn't want this panel to proceed on the basis there was an express power to repay.
I was thinking of the English provisions.
There is in the English provisions, but in Cayman there isn't. It's simply avoiding the payment. And the meaning of that and the consequence of that is something I think this panel is going to have to consider.
Listening to you both, it seems that the Privy Council has an oncoming portfolio of future litigation, which
Well, my Lord,
one special allowance of time.
one case with a number of issues, and addressing the time required is, as I said, something I'm going to have to put my mind to next week and write you a note about it. But
All right, well, I've got the message on unlawful.
Can we, I mean, if we're sort of winding down on this point, which I have the impression we are, could you just clear my mind on one thing? I mean, Patel and Mertzer, Lord Sumption's judgment was referred to by Mr. Smith, but he didn't refer to what page, this is volume 2, page 1362, to what arguably seems to be the clearest statement of the principle on which he relied, which is in a case called Neville and Wilkinson, 1782. This is on page 1362, 251. And there may be an easy answer to this, and no doubt Lord Sumption will know it, but I just thought I ought to mention the point. You've got it, 1362, middle of the page. In Neville Wilkinson, Thurlow LC referred to Lord Mansell's statement and declared his opinion that in all cases where money was paid for an unlawful purpose, the party, though particeps criminis, might recover at law, and the reason was that if the courts of justice mean to prevent perpetration of crimes, it must be, but not by allowing a man who has got possession to remain in possession by putting the party back.
That's part of joint criminality, isn't it?
But it's not.
Yes.
It's part
Oh,
of
it is.
criminal.
No,
Yes, particeps criminis is...
Yes.
Well, the party,
Paid for an unlawful purpose, that means by the other party.
well, not necessarily. I mean, it's here the payment is for an unlawful purpose, and the payer is participating.
What is being said is that in this kind of case, although both parties are involved, you can always get it back because it's consonant with the purpose of the statute.
Well, I mean,
You should have
if
to.
that's how you read it, fine. And
Well, I think
maybe, but I mean, it's not what it says. But
I think it does.
Anyway, Mr.
Participates
well,
criminis.
participants is single. The person, it's not saying both parties are participants.
well, but the particeps
Never mind,
criminis
Mr.
is the
Smith.
party who's trying to recover.
But it's it does seem to me that it actually states something which is.
Do we have Neville and Wilkinson?
Lord Newberg and Lord Mance and yourself in the same case, paragraphs 148 and 195.
148.
But I mean, Mr. Smith, if you're not relying on it, then I say no more.
Well, I mean, we've relied on it in the sense where it's part of the exposition of the Smith and Bromley line go to.
But I mean, the fact is that since 1782, we don't seem to have
Yes.
seen an illustration of its application to a case like the present.
It puts at paragraph 147 as reference to Smith and Bromley, and then Neville and Wilkinson is referred to 148 in that context. And likewise, Lord Mance's speech, 194 and then 195. But I mean, it seems to us that Neville and Wilkinson is essentially saying the same as that extract I took you to Lord Mansfield in the Browning case.
Yeah, but I mean, what struck me about it is that it's simply talking about the participation of the person
Yeah, I
paying
mean,
the money, not
But
about,
it's no use discussing
it says
this.
nothing about what the other person is doing.
It's no use discussing this case, it seems to me, without actually having the facts and reading the whole report.
The context in which it's discussed here is simply contracts which are themselves unlawful, i.e. a different situation to the one that we've got, so that there is effectively no consideration at all, and you simply, I mean, what Lord Chancellor Thurlow was saying was that in that situation you put the parties back as if the transaction hadn't happened.
yes, this is.
Because it hasn't in law, there's no consideration either way.
I think it's the words unlawful purpose that one gets that.
Yes.
Yeah.
Unlawful purpose suggests that both parties are the parties to that purpose.
So, and if the rule is there to prevent the perpetration of crimes, one assumes that there is knowledge on the part of the defendant of the illegality.
Yes.
I don't understand that at all. But anyway, never mind.
Well, but-
Simply, I mean, the whole point there, it's an unlawful
If you know
crime.
you can't keep, you don't commit the crime.
Anyway, leave it.
My lords,
Well, if
there's...
you discover between you that Neville and Wilkinson is a case where only the plaintiff was party to the illegality and in summary was paying for some illegal purpose to which, in a way which I am not quite sure one is easy to grasp, he alone was party, then let us know.
Well, this
but
is
we will look at
exactly that
it.
case. I mean, the only reason I refer to it is that it's the only support I could find for the idea that there's some underlying principle which supports Mr. Smith's position. I mean, but the fact that we haven't had an illustration of its application to any facts in the 200 or so years since then may mean that it's not of enormous importance. All right, thank you.
Right, now, Mr. Chivers, is there any more you want to say?
My Lords, only one very brief thing about, I think, what was my learned friend came back to, and it's interesting he came back to this, that he said that the purpose of this principle that he is trying to establish, or he says exists in this case, is to protect the general body of creditors against one creditor being paid in full.
Yes.
Well, if that were the case here, we'd be looking at preference-type claims. But in any event, if one is looking at the question of unjust enrichment in that context, one would look at it at the time of payment, not in the subsequent winding up. In other words, if you're trying to establish that a payment received by someone was that they have been unjustly enriched by that, namely that they have been put in a better position than their pari passu entitlement as against all creditors even, you'd have to establish that. So were that the basis for the claim, one would have to say, well, in other words, if the claim doesn't lie if everyone had been paid pari passu, I don't understand how my learned friend gets there or what relevance pari passu has to his claim. But if it is a question of some principle that only comes into play in the context of creditors being paid pari passu, the unjust enrichment aspect of that could only be looked by reference at the time of payment, and you'd have to say, well, you've got more than you are entitled to, and therefore that is unjust. So if the principle is in that form, my learned friends have not shown that there was an unjust enrichment of this person.
I'm not sure about that. I mean, isn't the rationale of the section that if you're unable to pay your debts as they fall due, then you shouldn't be paying out of capital?
Yes, but the question of pari passu distribution doesn't turn on pay as they fall due. It turns on
it may be that,
balance sheet issue.
No, I agree you can't compare it with pari passu, but you can say it shouldn't have been paid at all, I suppose, until the company's affairs have been sorted out in one way or another.
Well,
It can't pay its debts as it falls due, and it can't pay out of capital in those circumstances. Presumably either it'll never pay or it'll go into liquidation or it'll recover solvency and be able to pay them later.
my Lord, I accept all that. It was simply the way that my learned friend formulated it,
Yeah,
saying this
I've got
principle
that.
was to protect the general body of creditors against one creditor being
Yes.
paid pari passu.
I see that.
That can't work. My Lords, unless I can help you further, that's all I was going to say about this issue.
Yes.
Before my learned friend replies, he did make some submissions to you, I think, on the question of the solvency, remitting the solvency point.
Yes.
Would it be convenient for me just to say a few words about that now? You've seen from the document that was handed up that the question of solvency within the meaning of this particular provision page 2 of the agreed document, paragraph 3. So you see,
Yes, I'm afraid my copy of the document seems to have disappeared.
we hand up another one.
Thanks so much. Thank you. Yes.
At page 2, paragraph 3, see the way that this issue was set out in the 2X Fund statement of grounds, effectively their pleading, for the reasons set out in paragraphs 40 to 45, immediately following the date on which the payment of RMF's redemption request was proposed to be made, the 2X Fund was unable to pay its debts as they fell due in the ordinary course of business. And you'll see that that was the trial was directed by consent at A, the top of page 2, a trial of the following issues, a trial of the claims set out in paragraphs 57 to 60. So that included 59. So this issue was one of the issues that was before the court at trial. It's an issue on which evidence was led, albeit it seems in a documentary fashion only, but that was by agreement as well. Mm-hmm. And it's an agreement in respect, it's an issue in respect of which the finding made by the learned judge was that the 2X Fund was unable to pay its debts they fell due in the ordinary course.
Right, it's an issue in respect to which there was a finding?
Well, the learned judge found that the fund was unable to pay its debts because he disagreed.
The redemption.
He disagreed with the with the point that we are now bringing on appeal, namely that you excluded the debts of the redeeming creditors.
But if he was wrong on that, why shouldn't we send it back to find out the proper facts?
Well, it's our appeal in respect of that aspect.
Yes, but if you succeed, there's a void in the findings, isn't there? He hasn't
Well,
addressed the further question which would arise either way.
There's simply no finding.
Yes.
There is no finding as to the existence of any other creditor.
But that doesn't necessarily mean that he found that there wasn't any other creditor.
No, we say he made no finding. But there's been no appeal there's been no cross appeal in respect of that failure to make that finding.
I see, yes.
But he didn't need to make that finding, so.
Well, because on
the point is raised before us.
I mean, is it raised? It's raised in the submissions, and isn't that? Was it argued in front of the Court of Appeal at this point? Was it on the appeal to the Court of Appeal?
Was it? No.
Was there an appeal to the Court of Appeal on the grounds that a further finding should have been made?
No.
I see. Well, that's a. Do we have the notice of appeal to the Court of Appeal?
The notice of appeal is in the record. It's at 127 of the record, tab 7. Thanks.
Page?
127 is the notice of appeal.
And then there's grounds of appeal at 129.
Grounds start at 129.
So does that touch on this? Doesn't appear to.
No.
Respondent's notice as well.
Yes, I see. Right.
So the issue was put before the Court of Appeal that we're now running with you now. There were no debts within the meaning of the last section. But the appellant didn't
Yeah.
seek to alter their grounds of appeal to say, well, if that's right, there were actually debts and the judge should have made a finding to that effect. So that's where we end up today.
Thank you.
Well, the other thing I was going to do was I was asked to let you have a note on the comparison between the 1948 and the 1981 Act, the changes made by the 1981 Act.
Yes.
Lord Carnwath asked for that. Perhaps I can send that up afterwards for convenience.
Are you happy with that, Mr. Smith? Thank you much. Yes, very helpful. Thank you. Mr. Paul Smith, anything you want to add on this side? Thank you. Yes, Mr. Smith.
Well, I don't have any reply. It would just be repetition at this stage. So on the basis of submissions, Your Lordship.
Thank you very much indeed. The board is very grateful to Council for their helpful and clear submissions, and will take time to consider what advice it will humbly tender to Her Majesty.
We get the note first.
Yes, perhaps we could have the note, if you could get it and bring it outside.